your work permit risks being refused, even if it's complete, if it's not convincing. Many complete applications are refused when there's insufficient evidence to persuade an officer that the application should be approved. And that's because IRCC officers don't have to be correct. They don't have to be right. Their decision just needs to be reasonable based on the evidentiary record that you submit. So today we're going to talk about what evidence is enough to be persuasive and to close the gap or narrow the opportunity for an immigration officer to be able to reasonably conclude that you're not eligible. I'm Brooke Finley. I'm a regulated Canadian immigration consultant and the founder of Navio. We're a tech-enabled firm that offers affordable, modern support. To get started, click the link below to access Navio HQ. It's your hub for all things Canadian immigration, including templates and guides, and it's absolutely free to you. Again, link is below. Now let's dive in. Most people assume if they meet the requirements and upload all the forms and documents required, they'll be approved. But that's not the legal standard that an application is assessed against. In 2019, the Supreme Court of Canada clarified in a case called 𝐉𝐨𝐬𝐧 that a decision only has to be reasonable, meaning it doesn't have to necessarily be correct or the same decision that someone else might conclude if they were reviewing the application. And reasonable means that it's justified, it's intelligible, and it is coherent, that there is a logical link between the evidence provided and the conclusion or the decision made, and that decision references the information and documents provided in the application. And so if an officer makes that connection between the evidence and the decision, and that connection can be justified and it is intelligible, then even if you disagree or if someone else would have made a different decision, that refusal stamp. And when you combine that with the way that immigration law is written, the law is written in a way that says officers must be satisfied. An applicant must satisfy an officer. So that combined with the standard of reasonableness puts the burden on you to ensure that you've convinced the officer that you are eligible and that they are satisfied enough to approve your application. If an officer refuses an application and explains why they weren't satisfied, tying that to the evidence and information provided in the application, then that's a legally defensible decision. This matters because if you don't understand the legal test, you're building an application for completeness versus building one that will stand up against the test of reasonableness. Almost every single refusal I've seen has the same or similar wording, something along the lines of, "I am not satisfied." And in some cases, the application was incomplete. But in many, there was nothing obviously wrong. It just wasn't convincing and persuasive enough. The frame in which we'll discuss what enough evidence looks like. And spoiler alert, there's no hard and fast rule what enough evidence is. It comes down to a matter of criteria and how you look at the application and apply that to your circumstances. When an officer looks at your application, obviously they're looking to confirm that it's complete. And if it's missing any of the mandatory documents, it'll be refused. And most often, IRCC is not going to ask you to supply missing information. They will refuse it. Part of the reason is the volume of applications they're responsible for reviewing and the number of decisions they need to make, that there's not enough time to allocate to asking for information. The faster a decision is made, unfortunately, the better the statistics look with respect to processing times. So reducing the inventory of applications and making decisions faster is something that IRCC officers are held to in terms of their performance And so they're very unlikely to ask you to provide additional information because that's going to skew the processing times and the volume of decisions that an officer makes in a set period of time. Beyond that, what they're looking for is this believable? Is it consistent? And is it independently supported? When you're preparing your application, think about what documentation you can include that is independent or a third party supporting the claim that you're making. For example, if you state in your application that you have X degree, and that degree is directly related to your work experience and proof that you have the qualifications to do the job, you want to make sure you not just state in the application form that you have the degree, and not even just provide a CV that lists your education, because those are all claims that you're making. You need to support that with evidence. And so a copy of your degree and a copy of your transcripts can help as well as an employer letter that confirms the education you possess is relevant and applicable to the role that they've offered you. Another example is your work experience. Again, stating the work history in your application form and even providing a CV isn't sufficient. We want third-party letters. So a letter from the past employer, previous pay stubs, proof of your income tax filed from that period of employment, bank statements showing the wages you received to align with the pay stubs, for example. All of that is make sure that you're not just providing one document to support the claim, you've got multiple. And that makes a stronger application because it's harder for an officer to logically and reasonably state that they're not convinced when there's multiple documents that prove a certain claim versus with just one document. You know, if an officer believed that a employment reference letter was forged, or if they thought that a degree was fraudulent, then having other documents to back it up makes that line of argument less defensible from the reasonableness standpoint. The next thing is making sure the information and documents you provide are specific and consistent. If there's inconsistencies or one document contradicts information in your form, so if you have employment dates in your form that don't align with the employment dates in a reference letter or pay stubs, then that's going to create room for doubt. And when there's room for doubt, an officer can say that they are not convinced or satisfied. So making sure the documents support or are consistent with the other information provided in your application is essential. And I see this a lot where there's slight discrepancies in the dates on a form versus the dates in the supporting documents. So that's super important to make sure, go through your application with a fine-tooth comb and close any of those inconsistencies if they exist. And additionally, being specific. You can't simply say, or a supporting letter can't simply say, I have the previous experience to qualify for this job. You have to explicitly state what experience you have in the past and directly how it relates to the current job. And if you have, for example, you're moving up into a promotion, that's particularly a situation where you have to be very specific about how there is a logical progression, career progression. Otherwise, the officer can conclude that you're not qualified to do the job. Again, I'm just using examples of in my work and practice where we have built cases and made sure that we were very specific about somebody's past experience and directly how it relates to the job. And if you have experience in an adjacent industry to the one to the job offer that you've been made in Canada, again, that's another scenario where you really, really need to be specific about how your previous experience is going to translate into the new role. And then on top of being specific, including multiple forms of supporting evidence from independent third parties. Finally, anticipating any weaknesses in the application, because they all have a weakness. So figuring out what those weak points are and addressing them directly with evidence, being specific, and making sure that there's little room for an officer to conclude that they're not satisfied. So when you know that reasonableness and satisfying an officer are the legal tests, you can build your document package to support that. For example, I recently worked on a case where the job offer was below the median wage rate on JobBank. And it wasn't an LMIA. So it was an LMIA exempt application. And to address this fact, what I wanted to do was make sure that the officer didn't conclude that the job offer wasn't genuine on the grounds that the wage was below the median. And so I made sure that I demonstrated with multiple documents that the wage offered was consistent within the company's HR org structure, so that relative to other employees within the organization, that it was a defensible wage. And then I also looked at the industry-specific data. So what I did is I took our argument, our defense, beyond just the employer and proving that, well, to the employer, like this all checks out. And I added industry-specific data to prove that the job offer was genuine and to basically shut down any potential room that an officer had to conclude that the job offer wasn't genuine and refuse on that ground. Another example was someone being paid below the wage, and I took labor market data that showed the majority of Canadians working in this occupation were nearing retirement. So these are people who've been in the industry and gained decades of experience. So of course, that drives up the wage data when we're looking at medians. And I then explained and supported with evidence that it was reasonable for the employer to offer the wage they were offering because the person they were hiring was newer to the industry. And so we showed that with data from the employer and their company structure, as well as industry-specific data. And we even had a letter from an industry association confirming that that was a reasonable and defensible wage to offer someone with the skills and years of experience that this person had. So just some ideas of the types of issues to make sure you're addressing, as well as how you might address them with evidence and multiple forms of documents. An officer has to meaningfully engage with the evidence you provide. So if they ignore key evidence, the decision is unreasonable. If they misstate key facts, again, that's an unreasonable decision. If the decision is wrong in fact, meaning they didn't apply the correct law, that's unreasonable. For example, I've had applications refused, and the officer stated that the application as made didn't meet the requirements of, and stated the section of the law, when that wasn't even the type of application we clearly requested. So in those cases, we've been able to overturn decisions. So if the decision is wrong in fact or law, or if an officer doesn't engage with the evidence, or if the decision is procedurally unfair, then it can be deemed unreasonable. And this is super helpful because as you're preparing your application, Consider each of the requirements that you need to satisfy to be eligible and tie that directly to the evidence that you're providing. And that helps to build an application that is difficult to refuse on the grounds of reasonableness. And in my opinion, the best way to do this is to ensure that you have a submission cover letter that addresses all of the eligibility criteria, explains how you meet them, and specifically draws attention to the evidence you're including. And within that letter, make sure you have a clear evidence table. And I've even liked to include an evidence matrix. So stating all of the requirements of the type of permit you're requesting, and then the supporting evidence that you've included that substantiate your claim of eligibility. So making sure your application is structured in that way and not just submitting the documents that are listed in the checklist, or, the opposite of that, inundating an officer with documentation without tying it directly to how you're eligible and making it easy for the officer to evaluate the documents you've submitted against the eligibility criteria. That's really what is going to build a strong application. So here are the 5 ways to build a Vavilov resistant application. Number 1, avoid ambiguity. Number 2, corroborate material claims. Number 3, mirror statutory language, meaning understand the eligibility criteria and make sure you map your evidence directly to the requirement of the law. Number 4, address ambiguity directly. That doesn't mean that you have to say, hey, I think you might refuse me for this reason, but rather make sure you are aware of the potential risks and weaknesses in your application and bolster that part of your application with as much evidence and justification as you can. And number 5, structure the record clearly. Make sure you're not just padding your application, but be very discerning in the documents you include, ensuring they're the strongest evidence that you can gather to support your claims that in turn demonstrate your eligibility. And when you build your file this way, a refusal requires stronger reasoning and rationale, which makes an approval more likely. So before you submit your application, ask yourself this: if you were the officer, would you be ignoring evidence that's on the record if you refuse the application? If the answer is no, then you have gaps to fill. So now you understand how officers assess applications against the reasonableness standard and hopefully have a better idea of what enough evidence looks like. But there's one area of work permit applications where officers are repeatedly dissatisfied and the ground on which we regularly see refusals, and that's temporary intent. And that means your ability to convince an immigration officer that you'll leave Canada at the end of your authorized stay. That's why I've dedicated an entire episode to addressing this issue. So don't forget to hit the like and subscribe so you don't miss the next episode on how to convince an immigration officer you'll leave Canada by the end of your temporary authorized stay.